The crime of obstruction of justice, in United States jurisdictions, refers to the crime of obstructing prosecutors or other officials. Common law jurisdictions other than the United States tend to use the wider offense of perverting the course of justice. Legal overview: generally, obstruction charges are laid when it is discovered that a person questioned in an investigation, other than a suspect, has lied to the investigating officers. However, in most common law jurisdictions, the right to remain silent used to allow any person questioned by police merely to deny answering questions posed by an investigator without giving any reason for doing so. If the person tried to protect a suspect or to hide from investigation of their own activities, this may leave them liable to prosecution. Obstruction charges can also be laid if a person alters, destroys, or conceals physical evidence, even if he was under no compulsion at any time to produce such evidence. Often, no actual investigation or substantiated suspicion of a specific incident need exist to support a charge of obstruction of justice. Obstruction can include crimes committed by judges, prosecutors, attorneys general, and elected officials in general. It is misfeasance, malfeasance or nonfeasance in the conduct of the office. Most commonly it is prosecuted as a crime for perjury by a non-governmental official primarily because of prosecutorial discretion. Notable examples: President Richard Nixon was investigated for obstruction of justice for his alleged role in the cover-up of the break-in at the Watergate Hotel during his 1972 re-election campaign. Although it is unknown whether Nixon had foreknowledge of his re-election committee's dirty tricks campaign against Democratic presidential candidates that led to the break-in, he was aware of it after the fact and paid money to keep the participants quiet. Former Vice Presidential Advisor I. Louis Scooter Libby was convicted of obstruction of justice in March 2007 for his role in the investigation of a leak to reporters that named a CIA agent, Valerie Plame. His prison sentence was commuted by President George W. Bush in July 2007, so that Libby was no longer required to serve a 2.5-year prison sentence, but still required to pay a $250,000 fine, be recorded as a convicted felon, and obey probation terms. Conrad Black was convicted of obstruction of justice in July 2007 for removing 13 boxes containing financial records from his office in Toronto after they had been sealed by a court order, returning the boxes a few days later. Barry Bonds was convicted of obstruction of justice on April 13, 2011 for his testimony in front of the grand jury during the BALCO steroid scandal. The conviction was later overturned by an appellate court. In United States v. Binion, malingering or feigning illness during a competency evaluation was held to be obstruction of justice and led to an enhanced sentence. Obstruction trends: anticipatory obstruction of justice has recently appeared on the horizon in cases such as U.S. v. Wolf. However, the operative section, 1519, passed in 2002, has thus far languished in quasi-obscurity. Titled OE Destruction, Alteration or Falsification of Records in Federal Investigations and Bankruptcy, the provision was passed under Section 802 of the Sarbanes-Oxley Act of 2002. The text of the statute is relatively straightforward. Whoever knowingly alters, destroys, mutilates, conceals, covers up, falsified, or makes a false entry in any record, document, or tangible object with the intent to impede, obstruct, or influence the investigation or proper administration of any matter within the jurisdiction of any department or agency of the United States or any case filed under Title 11, or in relation to or contemplation of any such matter or case, shall be fined under this title, in prison not more than 20 years, or both. Aside from Section 1519 unregistered trademark's 20-year maximum prison sentence, its primary appeal is that it uniquely removes certain key proof burdens from prosecutors' unregistered trademark collective shoulders. Prosecutors charging violations of Section 1519 must still establish both of the following: the accused knowingly directed the obstructive act to affect an issue or matter within the jurisdiction of any U.S. department or agency. The accused acted at least OE in relation to or OE in contemplation unregistered trademark of such issue or matter. Not on the list, however, is the requirement that prosecutors demonstrate to the finder of fact which specific or pending proceeding the accused attempted to obstruct. That is a significant benefit to the government. See also, false evidence, obstructing government administration, perverting the course of justice, a similar concept in the Commonwealth of Nations, jury tampering, witness tampering, spoliation of evidence. Footnotes. External links, Obstruction of Justice, an overview of some of the federal statutes that prohibit interference with judicial, executive, or legislative activities, Congressional Research Service, December 27, 2007, Obstruction of Congress, a brief overview of federal law relating to interference with congressional activities, Congressional Research Service, November 5, 2010.